Good afternoon, everyone. I'm Alan Gingell, the Executive Director of the Lowy Institute, and welcome to our second Wednesday lunch at Lowy for 2009. Today's lunch coincides with the launch of a new policy brief by one of my colleagues, Fergus Hanson. He has a Masters in International Law from the University of Sydney, and he was an Australian diplomat working for the Department of Foreign Affairs and Trade from 2004 to 2007, and from 2005 to 2007 he served at the Australian Embassy at the Hague, where he was responsible for Australia's relations with 5 of the international legal institutions which are housed at the Hague, including the International Criminal Court. He's now written a very interesting paper for us on modern war criminals in Australia, and I invite him to talk to you about it. Fergus Hanson.
To start off today, I thought I'd briefly talk a bit about the genesis of this paper, and then, as Alan mentioned, before starting here, I was working at the Australian Embassy in The Hague, covering the international courts and tribunals based there. And I started out falling into the trap of seeing the various war crimes trials taking place there as somewhat removed from Australia's direct national interest. Australia, it seemed, was a long way away from the world of genocide, mass rape and torture. But quite early on, I was corrected in this misperception when a senior official in The Hague approached me saying our people back in Canberra might be interested in a dossier they had on a suspected war criminal living in Australia. That short direct encounter and other subsequent research left me with the impression that something was amiss with Australia's war crimes policy. With the election of the Rudd government, it looks like things might at last be about to change. Over its long period of opposition, the ALP parliamentarians have pointed to Australia's potential safe haven status, and the party came to office promising to close the loopholes in Australia's war crimes legislation and to review resources dedicated to investigations to ensure that perpetrators found here would be brought to justice. This paper is an attempt to take a broad look at what Australia is doing to end impunity for war crimes, and in particular modern day suspected war criminals. I'll begin with some brief background and then look at why it is likely that Australia may have inadvertently admitted a substantial number of war crime suspects. I then want to address why Australia should or needs to take action now, before looking at its current policies and a comparison with Canada. I'll then finish up with some suggested recommendations. And I should point out from the outset a few caveats. I'm talking here about suspected war criminals only, and the normal presumption of innocence should naturally apply. I also use the term war crimes to also cover genocide and crimes against humanity, just as a shorthand. And finally, the purpose of raising this issue is not in any way to make some sort of veiled attack on refugee and migrant populations. It's merely to draw out some of the issues that I'll be covering here today. So first, a bit of background. Australia's history dealing with war criminals is patchy. Immediately following the Second World War, we tried around 800 Japanese defendants in and outside of Australia, resulting in over 500 convictions and more than 100 executions. But further action wasn't taken until 1986, when an ABC series, and I noticed today the person who created that series is in the audience, Mark Aarons. When that series sparked the Menzies Review into World War II war criminals living in Australia and the subsequent establishment of a Special Investigations Unit. Now, these investigations led to charges being laid against 3 individuals, but it resulted in no convictions, and the unit was disbanded in 1992. Then, about 7 years ago, recognising the problem posed by modern war criminals, the Department of Immigration established a dedicated war crime screening unit to screen for suspected war criminals before they entered Australia. In December 2005, this was temporarily supplemented by the creation of a War Crimes Task Force, when it emerged that Saddam Hussein's bodyguard was living in Adelaide, and in a separate incident, a suspect from the former Yugoslavia was living in Perth. This task force investigated 82 discrete cases before it was disbanded in June 2006. A threshold question for this paper has of course been whether there are actually any suspected war criminals likely to be living in Australia. And until a domestic law enforcement agency is given the resources to look into allegations, it's impossible to say with any accuracy how many suspects might be present. However, there are 4 reasons to believe that significant numbers might be present. First, we already know that suspected war criminals have slipped through Australian border checks. The Menzies review that I mentioned earlier identified serious gaps in Australia's initial post-World War II war crimes screening program. The investigation unit that was subsequently established conducted over 800 investigations and identified 27 cases where it was satisfied that the suspect had committed serious war crimes but was not able to gather sufficient evidence for a prosecution. Now, most World War II war criminals are now obviously dead, but border screening for war criminals is only a relatively recent phenomenon, and officials privately suggest that screening may have been a problem at other times since the Second World War. The second reason is that other countries ask us to extradite alleged war criminals from Australia to face trial. Now, the number of extradition requests remains small. The Commonwealth Director of Public Prosecutions reports just 3 in the last decade. But that doesn't necessarily indicate that there's not many war criminals present in Australia. It could reflect, for example, the lack of resources available to look into allegations, both in Australia and in the war-torn countries from which these people have come. And it could also reflect the delays associated with our extradition process, which has never been used successfully in a war crimes case in Australia. The third reason is that we already know suspected war criminals are misusing the refugee process to enter Australia. Over the last decade, the Administrative Appeals Tribunal has upheld 23 decisions to revoke or cancel refugee protection on the basis of war crimes. And the fourth reason comes from a comparison with Canada, which I'll return to shortly. So why does Australia need to do something about suspected war criminals living here? Since the establishment of the Yugoslav Tribunal in 1993, to prosecute the worst offenders from the Balkans conflict, there's been a dramatic revival in interest in international war crimes issues. There are now international courts or hybrid international courts for Rwanda, Sierra Leone, Cambodia, Iraq, Bosnia, East Timor and Lebanon. And in 2002, the world's first permanent international criminal court, the ICC, was established with Australia as a member. There has been a parallel growth in interest in domestic war crimes units too. The logic of this system argues that as fewer countries provide safe haven, the scope for impunity will be significantly diminished. Western countries that have so far established war crimes units include the United States, Canada, Belgium, Denmark, the Netherlands, Norway and Sweden. Now, Australia has been wholehearted in its support of international war crimes efforts, and last year gave over $15 million to international criminal courts and tribunals. However, that system is intrinsically connected to national efforts, and so far Australia's have been virtually non-existent. This is despite the fact that under international legal agreements, such as the Rome Statute for the International Criminal Court or the Geneva Convention, Australia has committed itself to taking action against war criminals. As the international consensus moves further towards ending impunity for suspected war criminals, Australia will likely find itself under increasing pressure to take action. I want to turn now to look at the options Australia has available to it to deal with this issue. Australia's first line of defence against war criminals is through border screening. The War Crimes Screening Unit performs this role by screening citizenship and visa applicants before they enter Australia. It has a staff of about 10, which is about double the number from 2005, and looks set to increase to around 16 shortly. However, migration statistics highlight the difficulty that screening out suspected war criminals presents. Just last year, the department issued over 13,000 humanitarian and refugee visas, 158,000 migrant visas, and some 3.6 million visitor visas. To assist it with border screening, the Immigration Department maintains a movement alert list of people with serious criminal records or whose presence in Australia might constitute a risk to the community. There are about 640,000 names on this list, and about 7,500 of those relate to war crimes. But to put that in perspective, the databases maintained by the Yugoslav Tribunal contain evidence that tens of thousands of people were involved in the commission of war crimes in some form in that conflict alone. The War Crimes Screening Unit does liaise with the Yugoslav Tribunal. However, the databases that this court and others maintain are not always easily accessible in a timely way. In the case of the International Criminal Court, which will likely soon have the largest modern war crimes database of any international court, no country yet has informal information exchanges in place. Once suspected war criminals enter Australia, there are essentially four main options available to the government: prosecution, extradition, citizenship revocation, or denial of refugee protection. Now, not every remedy will work in every situation, so the full gamut of options needs to be left on the table. But despite the need for a wide range of responses, the government's official policy remains to seek prosecutions. This is the most direct way of confronting the issue, but is fraught with difficulties. To start with, prosecutions are the most expensive remedy. A recent review of Canada's war crimes program found that the cheapest prosecution cost around $5 million. This is because war crimes are generally committed overseas, usually in war zones, making the collection of evidence and location of witnesses extremely difficult. Australia also has some glaring legislative gaps when it comes to war crimes. Genocide wasn't a crime under Australian law until 2002. Neither were crimes against humanity or war crimes committed in non-international armed conflicts. Now, this is glossing over some of the fine print, but you certainly get the picture. And this is not to say that prosecution should never be used in Australia, just that they're very difficult and should be seen as one of a number of possible options. But perhaps the single biggest obstacle to running prosecutions in Australia is the absence of any dedicated resources to investigate allegations of war crimes. The AFP is the responsible agency, but it assigns resources using a model that in practice means war crimes cases are never prioritised because they are perceived as unlikely to succeed. Not surprisingly, perhaps then, no prosecution has been initiated in Australia since the War Crimes Unit of the late 80s and early 90s was disbanded in 1992. Extradition is theoretically a quicker, more efficient and cost-effective alternative to prosecution because trials run in a place where the alleged events occurred can be much easier to conduct. And unlike other options like citizenship revocation, which I'll discuss shortly, alleged war criminals still face trial. In practice, however, a number of factors have worked to stymie this option, not least of which is that in most countries where war crimes have been committed, justice systems have collapsed and along with governance structures. Extradition is a lengthy and cumbersome process in Australia that has never been used successfully in a war crimes case. A report by the Attorney General's Department in December 2005 identified a raft of problems and blockages in the extradition process. And as I understand it, proposals to reform the system are currently being considered by government. Stripping people of their citizenship is the third main way suspected war criminals could be removed from Australia, and has been a method pursued by a number of other countries around the world. Amendments to the Australian Citizenship Act in 1997 widened the scope for stripping people of citizenship on the basis of migration-related fraud. It also removed the 10-year time limit that once applied, but these provisions do not, of course, apply retrospectively. Stripping suspected war criminals of their citizenship, while having the potential to be easier than prosecutions or extradition, also has its difficulties. The person does not face trial for war crimes offences, and the minister's ability to revoke citizenship is restricted in some circumstances where, if by doing so, the person would become stateless. Incidentally, no Australian has ever been stripped of their citizenship on the basis of war crimes. Finally, for suspected war criminals who misuse the refugee program to enter Australia, stripping them of their refugee protection is another alternative option available. Article 1F of the Refugee Convention allows states to deny protection where there are serious reasons for considering a person has committed a crime against peace, a war crime, or a crime against humanity. This option, again, is not without its problems. The person's case is heard by an administrative body that has no real background or expertise in war crimes issues, and where a lower standard of proof is required. There is also no need under the Refugee Convention to balance the seriousness of the alleged crime against the possible harm they face if returned to their state of origin. If people are refused refugee protection or have it cancelled under Article 1F, a practical problem can also arise of how to deport them. A receiving state must be found, and again, some people are stateless. An investigation in 2005 by Fairfax journalists identified a number of people denied refugee protection living in the Australian community, some for over a decade since first confessing to atrocities. At first glance, a policy focused on prosecutions appears the most comprehensive. In practice, however, a single approach will never cover all circumstances. Australia needs to be ready to use the full range of options available to it. These remedies, such as citizenship revocation or the denial of refugee protection, are not perfect, but they are an important part of any comprehensive response needed to deny safe haven in Australia. I want to turn now to a comparison with Canada, which has the potential to offer some policy lessons for Australia. Canada, like Australia, has a significant ability to regulate people movements across its borders and operates a large migration and refugee program. Unlike Australia, however, Canada has established a domestic war crimes program. This emerged from its attempts to try Nazi suspects in the late 80s and early 90s. These attempts, as they were unsuccessful as they were in Australia, but Canada took measures to remodel its program. In 1995, it shifted away from seeking prosecutions and focused instead on revocation of citizenship. A few years later, it announced a major whole-of-government approach to this issue. Like Australia, Canada has a war crimes screening unit that includes, in fact, the training of Australian officials on border screening procedures. This has stopped some 3,300 unwanted entries since 97-98. In Australia, the Department of Immigration doesn't always publish equivalent figures, but in the year 2004-05, its annual report states that 7 recommendations were made for refusal in relation to war crimes. These and other comparisons between Canada and Australia are imperfect because Canada's population is about 12 million people more. Canada has about 12 million more people, and over the last decade, Australia has taken about half as many migrants and refugees. The comparisons do, however, suggest that Australia's actions against suspected war criminals are not proportionate to the possible numbers present, and if it did devote resources to investigating allegations, a substantial problem might be identified. Given the strong systems that Canada's had in place for over a decade to try and prevent war crime suspects entering the country, it is noteworthy that it still has uncovered a significant war crimes problem domestically. Since 97-98, Canada has conducted about 1,800 police investigations into suspected war criminals. The AFP, by contrast, reports having conducted about 30 investigations. Since the mid-90s, Canada has shied away from prosecutions, as I mentioned, although it hasn't ruled them out completely. And in 2005, charges were laid against a man of Rwandan background following a 5-year investigation. Revocation of citizenship has been an alternative method used over the years, with 21 cases under review in the latest reporting period. Exclusions from refugee protection under Article 1F are also common, with 564 exclusions over a 9-year period from 97-98. That compares with 23 in Australia. 3 weeks ago, Canada released a major review of its war crimes program, which emphasised its continuing importance. And the following is a quote from its key findings. There is no indication that the number of allegations of those seeking to enter Canada or already resident will decline. The combination of new conflicts, the changing pattern of immigration to Canada from countries in conflict, and allegations arising from older conflicts indicate that the program will continue to deal with a significant volume of allegations. In the 4 decades leading up to the 1990s, there was a steady increase in the number of wars being fought globally, ushering in the next generation of war criminals. Strong grounds exist for believing Australia has inadvertently admitted suspected war criminals over the years. And while the Australian government has begun to confront the challenge via the establishment of the War Crimes Screening Unit, much more needs to be done to address the issue. International efforts to end impunity for war crimes require responsible countries like Australia to take action against suspected war criminals living within its borders. This is needed to meet community expectations and stated government policy. It is also important to uphold the integrity of our legal and immigration systems. And it would also complement the government's wider agenda, seeking multilateral solutions to global problems and demonstrating its credentials as a good international citizen in the context of the UN Security Council bid. International experience shows that dealing with suspected war criminals is immensely difficult, and there are no quick fixes. But a few modest reforms would go some way towards beginning to confront the issue in Australia. And the following are a few suggested recommendations. First, the government could make a clear statement on its policy towards suspected war criminals to guide bureaucratic policy setting. This should include clear guidance on its preferred approach. Prosecution should not necessarily be ruled out in some circumstances. However, a practical solution would focus on the full range of options, including extradition, citizenship revocation, visa cancellation, and exclusion from refugee protection, depending on the circumstances. Second, it should commit dedicated resources by establishing a small war crimes unit within the Australian Federal Police. This unit could conduct a preliminary inquiry which should include awareness raising in key communities to ascertain the scale of the problem. It could then investigate a small number of the most appropriate cases each year. In this context, border screening resources should also be strengthened with a view to further enhancing preventative measures. Cost is obviously an important consideration, particularly with the Commonwealth budget under growing pressure because of the financial crisis. However, the financial implications are quite modest. Australia gave over $15 million to international criminal courts and tribunals just last year. The cost of a war crimes unit, by contrast, can be much less. Sweden's unit operates on an annual budget of $1.7 million and the Netherlands unit on $4 million a year. Third, the government should push ahead with its election commitment to close the loopholes in Australia's domestic laws relating to war crimes, and should extend this to a review of other obstacles to efficiently dealing with suspected war criminals, such as the extradition process. Fourth, Australia should look to strengthen international cooperation by working to establish informal channels for information exchanges on suspected war criminals with the International Criminal Court. As the world's only permanent international criminal court, it will likely be the future repository of a great deal of information on war crimes allegations. Options for strengthening information sharing between like-minded states should also be explored. including via the establishment of a common war crimes database or information sharing protocols, with appropriate safeguards in place to protect against erroneous information unfairly prejudicing a person's immigration prospects. I thought I'd end today by quoting from a statement Joe Ludwig was reported as making when he was the Shadow Justice Minister. It's all well and good for the Minister to talk about the legislation that's in place, but what he needs to do now is direct action that will actually enforce those laws. We risk looking like a safe haven for war criminals. Thank you, and I look forward to your questions.